Today we're holding this event in an unusual format, in a hybrid format. Our speakers on the Russian side are present in this hall, so we will also have speakers who will be making their presentations remotely. This is a usual format for, as far as I know, at least in the past months. Let us try and use this format as well today. Our session today will be focusing on the Lisbon Agreement on international registration of appellations of origin and geographical indications. What is special about this session is that our interpreters are working together with our technical experts to provide simultaneous interpretation of all the speeches. And I hope we will have no failures, technical failures in this respect. If, God forbid, they happen, please let me know about it. Our event is a logical continuation of the meeting which we held today in the morning, where we discussed geographical indications in the Russian Federation. We discussed the latest changes in the Civil Code of the Russian Federation, and I think that the year 2020 can be considered a milestone in this respect, because not only the Russian Federation has seen significant changes in its legislation, but also the Geneva Act of the Lisbon Agreement came into force. The Geneva Act on international registration of geographical indications and appellations of origin. It came into force because the EU has joined the Geneva Act, and Mr. Clark from the EU is going to tell us about it today. So I believe that the accession of the EU to the Lisbon Agreement will give a new impetus to the development of this system. And we hope that the users from the Russian system of protection of geographical indications and appellations of origin, users that exist in Russia, will consequently become users of the international Lisbon system. Appellation of origin is nothing new to us. We have had it in Russia for a long time. We already have some experience working with applications to register appellations of origin. And our users also have experience in protecting their rights. Geographical indications is something new to the Russian law. But this year, after the latest changes in the Civil Code in the Russian Federation came into force, Rospatent has already begun to accept applications for this IP item as well. So we hope that the system for protection of appellations of origin and geographical indications will be developing, and that we will join the Lisbon Agreement on international registration of these items of IP. And I'm satisfied to state that the Rospatent initiative to join this agreement is already being implemented. Work is underway in this respect, and our experts are going to tell you today what particular steps have been made and what we expect to see in the near future, what next steps will be made in this respect. And now it is a special pleasure for me to give floor to Mr. Albigonov, Zhuravlev Albigonov. We all know him as an expert. He is my colleague at Rospatent. Used to be. Zhuravlev Albigonov will make an opening statement on behalf of the Russian office of the WIPO. They've been helping us a lot in our work, to work with our global systems such as BCT, the Moderator system of international registration of trademarks, and the Hague system of international registration of industrial designs. I would also like to say a few words about the fact that we joined the Hague system a short time ago. 2 years have passed since we have begun to accept applications for industrial design. We've seen a very good pace in this respect in international application from Russia. For instance, in 2019, we came 7th worldwide in terms of applications, which is a good design, which is a good result, in my opinion, for such a short period after we only joined the system a year earlier. But still, in my opinion, there's quite a lot to be desired with respect to the activities of Russian users of the Hague systems, as well as other systems. The inflow of applications to Rus patent is unfortunately much higher than the inflow of applications from Russian users. We will work together with Mr. Zhuravlev in this respect. We will promote the global systems in the Russian regions, including the Lisbon system, if we join the system. I hope this will be done in the very near future. So, Mr. Hassanov, you have the floor. Thank you very much, dear Andrey, for your very good words. About as regards the Hague system, I think the future will bring everything. We still have a lot to do. We have a very good future with respect to the Hague system, but I hope also with respect to the Lisbon system, which we're going to discuss today. So good afternoon, dear colleagues, ladies and gentlemen, dear friends. It is a special honor and privilege to greet you on behalf of the World Organization, Intellectual Property Organization, in this session, which discusses the accession of Russia to the Geneva Act of the Lisbon Agreement on international registration of appellations of origin and geographical indications. I would like to extend my special welcome to Ms. Alexandra Grazioli, our colleague from Geneva, Director of the Lisbon Register. And my special greetings go to Mr. John Clark, Mr. Eric Tevenot. I would like to thank them for finding the time to participate in our session in this hybrid format. I'm convinced that we'll find their contribution very interesting and very useful. The Russian Federation, as we have already heard, has been making very important steps to ensure legal protection of appellations of origin and geographical indications at the national level. We have seen the latest changes in the Russian law that have been discussed in the previous sessions. Furthermore, we discussed them extensively this morning during the plenary session, where the head of Rus patent, Mr. Zhuravlev, was attending, and so were other speakers from the Federation Council and the Government Duma. This will help as a very important impetus to the economic development of Russian regions. It will help to grow employment, to keep and to develop the diverse list of Russian products. And in this respect, it will be totally logical and important to grant Russian copyright owners special tools to protect the geographical indications and appellations of origins worldwide. And this was also discussed this morning by Ms. Gomerova, and she underscored how important it is to enter international markets and to protect copyright abroad. The Lisbon system, in this respect, has a system which has been developing quite actively in the past year, grants a very effective and very easy-to-use mechanisms for protection. In February 2020, 3 months after the EU joined the Geneva Act, it came into force formally. And this extended the coverage of the Lisbon system to the geographical indications, in addition to appellations of origin, and its list covered 52 states. Ms. Grazioli, I'm convinced, will share information about the key benefits of the Lisbon system, and in particular the Geneva Act to copyright owners. We would also like to invite those of you who are interested in this topic, those of you who would like to get more information about the Lisbon system, about its special features and the procedures, to participate in our online webinar to cover this topic, which is going to be held on October the 29th at 11 a.m. Moscow time. You can find the link for registration on the page of the Russian rep office of the WIPO and also on our official page on Facebook. Please let me assure all of you in Russia and my colleagues in Geneva that we at the Russian rep office of the WIPO will be happy to provide all the necessary technical and expert assistance as part of the Russia joining the Geneva Act. I would like to thank all of you and wish you a successful session. Thank you very much. Thank you very much, Zhuravlev. And now, let us proceed to begin the main part of our program. And I'm happy to provide floor to Ms. Grazioli, Director of the Lisbon Register of Brands and Designs of the World Intellectual Property Organization. Ms. Grazioli, you have the floor.
Thank you so much. Good afternoon to everybody. I would like first to thank Rospatent for having organized this session on the Geneva Act of the Lisbon Agreement and offering us the opportunity to present the main advantage of joining the system for Russian producer. In that presentation, I will try to explain where the Lisbon system is in terms of protection for Russian GIs abroad, and explain the main characteristic of the Geneva Act of the Lisbon Agreement and recent development. So I hope by the end of this presentation, you will clearly see the benefits of joining the system now. And I'm sure also the speakers that will follow me will clearly make a demonstration why it was interesting also for their country or intergovernmental organization to join the system. So everything starts with the protection of geographical indication by a protection first in the country of origin. So in the concrete case we are discussing now, first you need to have a protection in the Russian Federation. But then how will you get protection all around the world and in third country? So you have different possibilities to do it. A first option would be to go individually, country by country, and asking protection in every country where you are interested to be protected. But this means that in every country, you will have to follow the specific procedure of every country, often provide different kind of document, having to translate it in different language. So this might be pretty complicated for GI producer and also time consuming. Some countries have also decided to negotiate bilateral agreement. Here also, it takes time to negotiate this agreement. And so what producer can also try to do in order to speed up protection if their country joins some international system would be to follow the procedures that exist under international system of protection. So what you have at the international level, and most of you should be familiar, is the TRIPS agreement that provide a minimum system of protection for geographical indication for the all country member of the WTO. But currently under the TRIPS agreement, there is no registration system. Another option for those countries who protect geographical indications through trademark is to use the Madrid system that is also administered by WIPO, as you heard before by my colleague Zhuravlev. And finally, for especially those countries who develop protection of GI through the sui generis system, as is the case now with the Russian Federation, for protection of appellation of origin and geographical indication, you can use, if your country joins the system, the Lisbon system, And so instead of having to follow different rules of procedure for every country, you can, through a single procedure by WIPO, obtain protection in different contracting parties. So what is exactly the Lisbon system? The Lisbon system is currently governed by two acts. The Lisbon Agreement, which is the historic agreement that was negotiated in 1958 and which cover currently 30 contracting parties. But what is more interesting for you now is to look to the new version of that Lisbon Agreement, which is the Geneva Act that was negotiated in 2015 and which entered into force, as it was mentioned, in February 2020, following the accession of 5 contracting parties, and the 5th one was the European Union, as it was mentioned. So what are the main benefits of the Lisbon system and the Geneva Act in particular? So the Lisbon system was created to facilitate the international protection of appellation of origin and geographical indication through a single registration procedure by WIPO. And what is very important for the member of the system is to create a system that is very simple and accessible to GI producers. Currently, the Lisbon system is the only international register that exists for appellation of origin and GIs. And what is interesting is that it covers all kinds of products. It also enables now, with the Geneva Act, for countries who join to ask for payment of individual fees or administrative fees relating to the use of appellation of origin or GI. So this is a new flexibility introduced to take into account the specificity of some system, such as the system that you have in Russia. Concerning the legal benefits of the system, what is interesting is that once a geographical indication or an appellation of origin is registered in the system and protected by Lisbon member, the protection is indefinite. So there is no system under the Lisbon system of renewal fees. And every time a new country joins the system, also the protection of a registered GIs will extend to this new member, provided they accept to protect the GIs on their territory. The level of protection is also considered to be very high, corresponding to international standard. There is also a very interesting protection for the GIs. Once protected, they cannot become generic in the countries they have accepted their protection. And finally, you receive a title with the international registration under the Lisbon system, and you can take legal action in case there is a problem in one member of the system. The procedure also for obtaining registration is pretty simple, as you will see in this scheme. So what is important to start is to have a title, a protection in the country of origin, so a title of protection. Then the users of the GIs can ask their competent authority to request, to make an international application for the registration of their GIs under the Lisbon system by WIPO. WIPO will make a formal examination and will send the international registration to the different member of the Lisbon system, depending on which act the country of origin is member. And then the member who will receive this application will have 1 year to decide if on their territory they can or not accept protection for that geographical indication. So you see, this is a very simple system and also very flexible for every member to decide on their own if on their territory they can or not grant protection for that geographical indication. If you are interested to see which appellation of origin are for the time being protected under the Lisbon system, you can go on the WIPO website and consult our online Express database or the bulletin where you have all the details. Currently, we have about 1,000 registration under the Lisbon Registry. And as you see, the first applicant under the system are European countries such as France and Italy, And very interesting now, a country like Iran is applying more and more under the Lisbon system to protect its geographical indication and appellation of origin. A big variety of products can be protected, or at least their geographical indication can be protected under the Lisbon system. And as you can see on this slide, so food and agriculture product, wine and spirit, other drinks, but also handicraft and natural products such as marble, for instance. And if we move now more precisely to the Geneva Act and why it's now so interesting for lots of countries to join the system and how the Geneva Act has modernized the Lisbon system. So what we can see is that one of the most novelty of the system is the introduction of the concept of geographical indication in the Lisbon system. And we do not have now anymore only the concept of appellation of origin, which is a narrow concept. And with the introduction of the concept of geographical indication, we have now a definition which is similar to the TRIPS agreement. And so a biggest quantity of countries are able now to join the system. As you can see, greatest variety of product can so be protected now under the Geneva Act, thanks to that broadening of the definition. What is also interesting is that under the Geneva Act now also intergovernmental organization can join the system, and the European Union did it last November. The African Organization of Intellectual Property, who is also delivering regional title of protection for his member state, is also interested to join in future. So we are waiting for their accession. What is also interesting, and this was one of the main objectives also of the system, is to enable also countries who protect their geographical indications through trademark system also to join the system. So with the new Geneva Act, there is a better recognition of the different means that a country can have at national level to protect GIs, and whatever mean a country decide, they can join the system. Among the flexibility, so there are a greater recognition of countries who protect their GI with the trademark system, but something also interesting for many countries was the possibility now to request individual fees or administrative fees relating to the use of appellation of origin and GIs if they have this kind of system at national level. And also the protection of geographical indication was clarified under the Geneva Act. Now the rules are much more precise than what exists before under the Lisbon Agreement, which clear level of protection when the GIS is used on same kind of goods or when the GIS is used on different kind of good. And here is more the concept of dilution that is used to secure protection. There are also a general protection against any imitation of the use of the appellation of origin or the GIs, even when the GIs is used in translation or with expressions such as kind of type. General protection against the misleading of consumer. Protection against later trademarks that will not fulfill the condition of use of the geographical indication. And finally, most important also, GIs, once protected, as mentioned before, cannot be considered to have become generic in any country who decided to protect it. In addition, and on the other side, if we can say so, to this high level of protection for registered GIs and appellation of origin under the Lisbon system, there are also different safeguards that have now been introduced in the Geneva Act. And these safeguards are usual in lots of national legislation, such as protection of prior good faith trademark, possibility to continue to use personal name in business, possibility to continue to use plant variety and animal breed denomination, and clear also explanation through a grid statement that countries are not obliged to protect terms that they consider as generic on their territory. And finally, for interested party, it's also very interesting to see that under the Geneva Act, there is now an obligation for the member to secure a possibility for them to ask the country to issue a refusal if there is a problem with the protection of specific GIs. What is interesting to see, and we had several testimony of users of the Lisbon system in past years that explain how they benefit from the protection under the Lisbon system. And why it is important to obtain international protection of the GIs, I think you can see the example, for instance, of the value of appellation of origin and geographical indication for a country like Italy. It's a true economic and trade value. And the same also was recognized in a recent study published by the European Union that products recognized and protected by geographical indication can be sold at a higher price than products that do not follow this kind of quality scheme. So you can understand when you can sell a product at a double price at a product which is not a geographical indication on a specific market, that different producers might be interested in using these names, even if the product that they sell do not have the quality, do not come from the region. So if you don't protect your geographical indication abroad, there is a risk that some other producer on the market try to benefit from the reputation of the original product that you have developed in Russia. There is also the risk that some person try to apply for trademark and then can stop the protection of the GIs later on, or that the name, if it's not properly protected and the protection of that name enforced, is that with time, if the use of the geographical indication continue on different product, not having the relevant quality and origin, the term become generic, and so it will be of free use for everybody. So this, for all this reason, is very important to obtain as soon as possible protection for your GIs on third market. And so what are the current progress and potential of the Lisbon system? So currently we have 5 contracting parties who joined the system. So Cambodia, Albania, Samoa, DPR, Korea, and the European Union, what makes that currently under the Geneva Act, 32 countries are covered by the new act. We have different countries interested to join the system. Here you have an outlook of some countries who are in the process of acceding to the Geneva Act. And generally, the tendency that we see in WIPO is that several countries are now developing GI system at national level, and then are interested also in joining the Lisbon system, because they have seen that with geographical indication, they can use it as a tool to foster local development. Because GIs have very unique characteristics. They are a mix between, it's the only intellectual property rights that connect a production area with the know-how of a population and the reputation of a product that comes from that place. And because of the collectiveness of use of that geographical indication, we see that with GIs, there is a possibility to have a positive spillover effect on the development of region. If you are interested in this kind of discussion, I invite you to go on the WIPO website and see some examples that we have described in terms of seeing how geographical indication can also help to foster a sustainable development in terms of environment also. And more countries are also seeing a geographical indication as a tool to valorize implementing product and their tradition. So for all these reasons, we really think that in the near future, the Lisbon system will become a truly global system for the protection of geographical indication. And so we do hope that also Russian producers can see the benefit in joining that system and benefiting from that protection abroad. Thank you so much for your attention.
Большое спасибо, госпожа Грацоли.
Thank you very much. I have received a question already.
Я хочу
question
сказать,
to you.
что я думаю, вопросы можно
I
задавать
think
и
you
по
can
ходу
ask questions
выступления.
during
Лучше
the
в
speeches.
письменном виде печатать вопросы в чате
But it would be better to text your
YouTube-канала, по
questions
которому сейчас
in the chat of the
транслируется
YouTube channel
наша
where
секция.
our session is being broadcast currently.
Вопрос, на мой взгляд,
The question, in my opinion, is not an easy one.
новая страна, присоединившаяся,
A new country that joins the Geneva Act automatically undertakes all the previously registered geographical indications. How does this correlate with expert assessment at the national level? For instance, we in the Russian Federation carry out an expert assessment of applications, and we ask for assessment of particular features of a product in a particular geographical indication. Any country which joins the Act can submit similar comments, but when we join the Lisbon Register, we need to agree with all the registrations automatically. Did the listener understand the idea of the Lisbon system correctly?
Sorry, there is a name.
Да, я вас слышу.
Is it okay now? Yeah. So when a country joins the system and for application, it has 1 year to examine and decide if on territory it cannot protect the geographical inclusion. And this will do according to its national law. So what countries do mostly, they do a thorough examination of the definition, and what they mostly look at is the name generic of the territory, is the name conflicting with prior rights. So these are the kind of examinations that a country do. But now with the Geneva Act, country can also ask others to explain the link between quality reputation and the geographical area to make that assessment. So a country has 1 year to decide if it protects or not the GI. So it's not an automatic protection.
То есть, продолжая вопрос своего коллеги,
So, to continue the question asked by my colleagues, I would like to ask for clarification. Whenever a country joins the Lisbon system and the Geneva
мы
Act,
должны будем
we will have
пересмотреть
to
все уже
revise all the
зарегистрированные
previously
географические
registered
указания и
appellations of
наименования
origin
местопроисхождения
and
товаров,
geographical
которым уже
indications
предоставлено на экраны, и
that are already
за этот 1
protected
год и решить,
during this 1
каким
year, and we
конкретно
will need to
объектам мы предоставим охрану на территории России, а
decide
каким
which
нет.
particular
Я правильно
items
понял?
are protected in Russia and which are not. Is that right?
It's right, but just notice that if Russia joins the Geneva Act, it will only have to look to the GIs and appellation of origin that will be protected under the Geneva Act. So for the time being, the 1,000 registration I've shown you are protected under the Lisbon Agreement, not under the Geneva Act. So for the time being, if you join now, for instance, there will be nothing to examine. So, we expect that in coming years, we will receive some applications. So Russia will have to examine only those applications that are made by Geneva Act member if you join only the Geneva Act. So it will be progressive.
Большое спасибо за пояснения, с которых я понял, что чем быстрее мы присоединимся к Лиссабонской системе, тем, собственно, лучше будет для Роспатента. Так, ну пока вопросов больше нет.
We don't have any questions so far. So at the end of this session, we will have time for Q&A. Please don't hesitate to ask any of questions to any of the speakers. And now I'd like to give floor to Mr. John Clark, Director of the Department for Agricultural Development at the European Commission. I'd like to use this opportunity, Mr. Clark, And on behalf of the Deputy Chair of our agency, Ms. Lyudmila Kivina, I would like to extend her best wishes to you. Mr. Clark, you have the floor.
Thank you very much, sir. It's a great honor to join you in this conference dedicated to the Geneva Act of the WIPO Lisbon Agreement. And I'd also like to offer my most sincere personal best wishes to Mrs. Lyubov-Kiri. We worked together very closely many years ago in an EU-Russia working group on GIs. I have very, very profound and affectionate memories of her professionalism, and I hope that we can meet again soon. She was a very great colleague to work with. I'd like to share with you this afternoon a few thoughts about the potential benefits of the Geneva Act, the implications of the Geneva Act, of the revised Lisbon Agreement, and also how this Geneva Act agreement fits into the rapidly developing universe of GIs. And I'm going to now do a short PowerPoint presentation, and I hope that my IT skills will be sufficient. Can you see this? Yes? Could you confirm?
Да, мы видим вашу презентацию.
Okay, good. So what I'm going to do is do a very, very small number of slides just to structure a little bit my intervention. And I will begin with an explanation of why in the European Union GIs are important to our farming community. And the buzzword, the logo, the hashtag, if you like, is that good food is good business. For us, GIs have three important benefits. First of all, they are a form of intellectual property, but they're for the rural areas. So our experience has been that GIs actually help otherwise poor farmers and food producers join together in collectives, in producer groups, develop a product which has authenticity, has tradition, has know-how, has reputation, and through that they can actually make some money. And farmers in Europe, as all over the world, have very low incomes. Through GIs, a much bigger share of the value of a good accrues to the farmers. And as Alexandra mentioned in her brilliant presentation a few minutes ago, on average, a GI product has twice the value on the retail market as a otherwise comparable non-GI product, because people want to buy authenticity and quality and all of the elements that GIs bring. The second reason why the EU has been promoting GIs in the last 30 years is because they are really the flagship for quality products in the agri-food sector. GIs are a real representative of high quality, authenticity. They are made to very exacting production standards with a lot of know-how and care. And so, people know what they're buying when they buy GIs. And this translates into our export performance, the third point I want to make. The EU has, for the last 10 years, been the world's biggest exporter and importer of agri-food products, with a trade surplus of 40 billion, although unlike Donald Trump, we don't really care about the size of the surplus. But the point is that one of the main reasons for our success on world export markets, particularly in North America and in the emerging economies, is thanks to GIs, which are really the kind of the pioneer, the flagship of our quality, reputation, and added value. GI products are about 6% of our production in the agricultural sector. They are 15% of our exports. So that's just a couple of statistics to show that how important GIs can be in terms of our international trade performance because of the reputation that they carry with them. Now I'll move to the next slide. A word about the international context of GIs over the last 20 years. The Uruguay round in the WTO, and I was a participant in the TRIPS negotiations at the time. Of course, adopted the TRIPS agreement, which gave a basic level of protection to GIs. It also mandated negotiations on a multilateral register for GIs and increased protection for GIs beyond wines and spirits. In the TRIPS agreement of WTO, wines and spirits had a higher protection than other products. So from 1995 onwards, after the Uruguay round was concluded, we and others, we tried to develop this idea in the WTO of a multilateral register of GIs, a one-stop shop, if you like. We were not successful. Why is that? Mainly because the USA, Australia, Chile, New Zealand, one or two others, countries with no GI tradition, blocked it. I'll be very, very blunt. So we were not able to get a consensus in the WTO on a multilateral GI register. What do? We and others, Turkey, Japan, Korea, South Africa, others, we moved bilaterally, but not only in GIs, but across the board. And from 2008 onwards, the EU and other members of WTO decided that the best thing to do was to try to negotiate GIs protection bilaterally in our free trade agreements. And we pursued that with some success, and I'll come back to that in a few minutes. And as part of that process of moving into bilateral GI protection agreements, we saw that a lot of countries decided to set up their own GI systems. I would mention Korea, Japan, China, others, which I think is a recognition of the fact that many countries started to realize that GIs need to be put on the same kind of level playing field as other forms of IPR. But we did not give up hope about having a multilateral GI agreement, and we had the great fortune that in the 2010-2015, as Alexandra from WIPO has said, we had the chance to renegotiate the 1958 Lisbon Agreement, to update it, and to see whether we could actually turn that into a really modern, fit-for-purpose multilateral GI agreement of the kind that we had failed to achieve in the WTO. And I think, broadly speaking, we were able to achieve in the United Nations system in WIPO what we were unable to do in the WTO, and I will explain why now. So, what is the Geneva Act of the Lisbon Agreement, and what are its main features or benefits? It really is an act of modernization of the 58 agreement to take into account the development of a GI philosophy around the world in the last 30 years. First of all, the Geneva Act broadens the scope of the original Lisbon Agreement from appellations of origin, which have a very precise definition, to geographical indications, which is a more slightly more loose definition, which you find in the WTO TRIPS agreement. So I think that was an important element of the Geneva Act coming into line with modern IPR law, policy, and practice around the world. What is an AO? What is a GI? Secondly, and Alexandra, my dear colleague from WIPO, mentioned this, very unusually for the UN system, the Act was opened to international organizations and not reserved to member states, nations, which is the normal UN approach. So it means that the European Union, which is many things, but it's also a regional organization, OAPI, ARIPO, possibly in future the Eurasian Economic Union. If you have a regional IPR system, you can join the Geneva Act of WIPO in your own right. I think that's a very, very good and innovative approach, and certainly I think it makes the Geneva Act more attractive for many members, particularly those who are. I'm thinking particularly of OAPI and ARIPO, who bring together a large number of smaller countries into a regional system. Those countries individually may not find it appropriate to join Lisbon, the Geneva Act themselves, but they can do it via their regional agreement to which they are party. So it's a very logical and modern approach to UN membership. Move down. A few words about the EU's position in the Geneva Act. As Alexandra said, the Act came into force following the accession of the EU 27 member states in November. So it now is open for business. The European Commission will be the executive body in Geneva under the Geneva Act Article 3. We will be the body which will lodge applications for GI registration by members to the WIPO Bureau. We will do that following consultations with our member states, and we are actually quite now at this moment we are consulting the EU 27 member states on which GIs we should lodge into the Geneva Act. Now, don't worry, we're not going to propose that we would seek registration of all 3,400 EU GIs. That would be completely ridiculous, and it would inundate the system, so it would be counterproductive. Our intention is to request registration under the Geneva Act of maybe 200 European GIs, based on the production value of those GIs, their actual or potential export value, and the risk of misuse in third countries. That's the same approach that we use in bilateral agreements, and we would propose to do the same in the Geneva Act, because we don't want to overwhelm the system with a lot of unnecessary applications which are not really necessary from commercial terms. That was a parenthesis in some ways. Back onto the question of modernization. The other big innovation, I would say, with Geneva is that it really aligns itself to 2020's IPR law, policy, and practice, and certainly aligns the UN system to the WTO TRIPS agreement. So WIPO has actually caught up and almost overtaken WTO for the first time in 40 years. Geneva has a very high level of protection of GIs, comparable to TRIPS Article 23. It goes beyond that because it applies the same protection level to all GIs and not just wines and spirits. Secondly, the Geneva Act is my second bullet point here. It takes in account the WTO jurisprudence, which confirmed that there can be coexistence between a prior trademark and a subsequent GI, while fully safeguarding trademark rights. That's really enshrining in UN law and treaty the WTO jurisprudence on the trademark GI relationship. And particularly important, I think, is one feature of Geneva, which you don't find in the TRIPS agreement, as far as I know, is that once a GI is registered in Lisbon, it cannot become subsequently generic. That is very fundamental to us and to, I think, any GI producer, and it's very intellectually logical. What do I mean? If a GI is protected and only the genuine user, the territory of origin can use that GI, it would be very, very bizarre and counterintuitive if after protection it could be claimed to be generic. Protection actually strengthens the case against generic-ness. So a very logical proposal intellectually in the WIPO system. The third, I think, very important and welcome dimension of the Geneva Act is its flexibility, and there are two things I'd like to highlight here. The first is that the WIPO leaves completely free to members how they will implement the Geneva Act. It can be through a sui generis GI system of the kind that the EU has, that Turkey has, that Russia has, that India has, that China has. It can be through trademark law, which is the approach in the United States. It can be through consumer protection rules or labeling requirements, as is the case in Canada or the Philippines. So I think it's very important that the UN recognizes the diversity of the way in which members would want to implement the basic Geneva Act framework. And secondly, the other flexibility is that it enables members are free to charge fees to process the GI applications, and they can also charge user fees, which is a very familiar concept in the trademark world. And I understand that for Russia and for many other members, this was an important element in the process of negotiating and approving the Geneva Act, and we are absolutely fine with that. I think it's quite legitimate if countries want to charge fees to a reasonable extent. They should be allowed to do so. Now, I referred earlier to the EU and others' pursuit of bilateral trade agreements on GIs after the failure of the WTO talks. Just to end by saying that these are continuing. The EU has negotiated, prior to the Geneva Act being in place, we've negotiated high level of protection for GIs in a number of our bilaterals. Some of them are here: Vietnam, Singapore, Mexico, Canada, Mercosur, Japan, etc. And we are, as I speak, negotiating with Australia, New Zealand, Chile, Indonesia, and some Central Asian countries for GI protection. And that, of course, is endorsed, condoned by the WTO. Article 24 TRIPS encourages members to go higher and go further bilaterally, and we will do that with or without Geneva. But the question is why? That's because there are one or two areas where in bilateral agreements we can actually go a little bit further than the Geneva Act. We have 36 agreements in force, 13 negotiations ongoing, and the stock of GI names protected in Europe through bilateral agreements, the third country names, is about 1,600. So even though the Geneva Act is now in force, of course, it doesn't have very many members. We need to have more members, and until we have more members, we will have to continue negotiating bilaterally. But we would hope that more and more countries would gravitate towards Geneva, and therefore we would not need to continue what in the end are more time-consuming bilateral negotiations. In a couple of areas, the Geneva Act does not provide what we can do bilaterally. In particular, on enforcement, the WIPO Geneva Act does not require ex officio administrative enforcement of GIs. That's something which is very important to GI producers, to be able to have very easy, cheap recourse to enforcement in other countries, and that we can more easily secure through bilateral treaties. Also, here and there, we can, in our bilaterals, we can go a little bit further than Geneva on protection, preventing evocation, and we can also work out very specific agreements on products which are heavily contested through recognizing de facto prior uses on the market, even without trademark protection. And last but not least, in our bilateral agreements, we do foresee quite extensive cooperation agreements in the long term on GI development, GI protection, enforcement, and exchange of know-how, in particular between producer groups and farmers. And that's something which is not really foreseen in the Geneva Act, and why should it be? So all that to say that Geneva Act for us will be the new baseline, the kind of the go-to standard, but we will try and when we have to top it up bilaterally with other provisions. I'll end just by thanking you for listening to me, and the last slide leaves you with two important internet sites. The first one lists all the GIs protected in Europe through direct registration. The second website, all of the GIs protected through our bilateral agreements. Many thanks.
Спасибо, господин Кларк, за содержательный доклад.
Thank you, Mr. Clark, for this most informative report. We have very close contacts with the EU, and we always, both in our legislative practices and our enforcement practices, look up to the practices of the EU on trademarks and design samples. And now we're going to look up to the experience of the European Commission that is going to consider applications submitted under the Lisbon Agreement. Mr. Clark, if I understand you correctly, the EC is going to decide whether to provide protection in all the countries of the EU, both for the GI and the AO. Does this mean that all the EU countries have more or less harmonized legislation in this respect? Won't there be any contradictions between the laws of 27 countries and the EU legislation in this respect?
Let me answer your question. Yes, we have harmonized legislation in the EU, so all EU 27 follow exactly the same rules on GIs and are subject to the same requirements. And we will be proposing for protection under Lisbon, under the Geneva Act, a short list, if you like, of the most important GIs from, I hope, all of the 27 member states. I mean, some member states have more than others, but I hope that we can have a cross section from all the member states. There are 7 member states who are members of the old Lisbon Agreement, and they can continue to be members, but that does not affect the Geneva Act.
Thank you very much for your answer. I have another question here. I'm going to ask it right away. In your presentation, you underscored how important it is for how successful GIs were with respect to agricultural products. The EU has extensive experience in this respect. And how does it look with respect to products from other sectors? For instance, arts and crafts. Does the GI protection system enjoy any demand in this respect?
Exactly. We have at the moment at the EU level a unified EU-wide system for protection of agriculture and food GIs. We don't yet have at the EU level the same level of protection for I would call it non-agricultural GIs. Of course, because of the WTO TRIPS agreement, right, of which the EU is a member, we do provide protection for all forms of GIs. All forms of GIs, agricultural, non-agricultural. Yeah, that's a requirement under Article 22 of the TRIPS agreement. We don't provide the higher protection that is given to wines and spirits. So for non-agricultural GIs, the protection is assured across the European Union, but not in the same way in each member state. So some member states have a sui generis GI system for handicrafts or artisanal works. Others do it through trademark law. Others do it through labeling or consumer protection. Yeah, so we're not harmonized in terms of the EU 27 method of protection, although the protection is guaranteed. I hope that this will change in the next 2 years, partly as a result of Lisbon, the Geneva Act, and partly as a result of pressure from our trading partners. There's a lot of appetite in Europe to have a harmonized EU-wide uniform regime for non-agricultural GIs, handicrafts, and the like. The European Parliament is very, very keen to pass a law on this, and the Commission is now carrying out an impact assessment to look at what would be the pros and cons of an EU-wide regulation to protect and enforce non-agricultural GIs. So I'm actually quite hopeful that in the next during the life of this Commission, we will see some beneficial outcomes there, which I know will make a lot of our trade partners very happy.
Thank you very much for your clarification. Correct me if I'm wrong, not all IP items can enjoy the same level of protection as GIs and AOs. So far, you can train yourselves only to protect agricultural products. Is that right?
Well, yes and no. I mean, under our WTO TRIPS obligations, we have to provide a higher level of protection to wines and spirits. We do that, and we extend that to all agricultural products. We don't extend that protection EU-wide to handicrafts. Okay, so we're in line with the WTO, but that's all I can say. Some member states provide a very high level of protection to handicrafts, France and Italy, for example, but that's not uniform throughout the EU.
Thank you for this clarification. I don't have any more questions so far to Mr. Clark. And now I'd like to give floor to Mr. Eric Tavenomaty. The floor goes to Mr. Eric Tavenomaty, Advisor for Geographic Indications, Swiss Federal Institute of Intellectual Property. Switzerland, as far as I know, just like the Russian Federation, is now getting prepared to join the Lisbon Agreement.
Do you hear me?
Да, вас слышно.
Yes, we can hear you.
So, thank you so much. I'm going to... is it going to show my presentation without I should do anything else? Oh. So good afternoon, everybody. Thank you so much for ops. It seems there is a technical issue. Just trying to display my presentation. Am I doing wrong? Okay. Doesn't work? Does it work? Yes. No.
Да, работает.
Yes, it works. It works.
Okay. So thank you so much for inviting me and to share the Swiss experience in acceding the Geneva Act, because it's contrary to the EU. It's still we are still in the course of that process to access to the Geneva Act. Let me also have a special mention to Mrs. Zhuravlev-Kiri, with whom we shared some views during the 2015 diplomatic conference as non-members of the Lisbon Agreement, but being strongly interested in having such a global system for our geographical indications. Okay, so I don't know if I still have the hand. Yeah, seems to be the case. So first of all, I would like to introduce my presentation. I will try not to repeat all what was very brilliantly said before by Mrs. Alexandra Grazioli and Mr. John Clark. So perhaps a very more focused snapshot on our current reflections in this process. So first, we are Switzerland is attracted to participate to this system because it's the first global system for the protection, the registration and protection for all GIs. As it has been said, after the failure of the negotiations at the WTO, the interest of this system is that it sets a very high standard of protection, which is also a part of the system itself. So it's not only a registration, but also the level of protection. We are also considering that the mechanisms that are established by the Geneva Act are very transparent and flexible in order to address each particular situation, being the situation of a member regarding its own legislative, so legal system, but also the situation of each particular denomination. And we also, of course, consider that the attractiveness for new members should be increased, perhaps not only by the accession of Switzerland, but also, of course, now that it entered into force after the accession by the EU. So in comparison with other tools, as it has been said, the national procedures are very costly for GI stakeholders because of the need of having local lawyers, language issues, and also there are problems of compatibility with trademark systems or national requirements, let's say, for GIs. Bilateral agreements were also concluded by Switzerland. We have to mention in particular the agreement, the comprehensive agreement that was concluded between the Russian Federation and Switzerland in 2010. But our experience is that these bilateral agreements are only successful when there is mutual interest and willingness between the two parties, and also when the stars are aligned, let's say. So it was the case with a limited number of countries up to now, so included, of course, the Russian Federation. In our view, it will no longer be necessary to negotiate bilateral agreements with members of the Lisbon system or countries that are about to become members of that system. This will not prevent special agreements, as it has been said, regarding enforcement or regarding indications of source, generally speaking. And also it would not prevent direct talks or direct cooperation, be it on a very general basis or on specific cases. Now you can see very briefly the current process of accession for Switzerland. So our internal procedures are taking a lot of time, you may think, with lots of consultations. So the public consultation was, let's say, very successful regarding our proposal, both regarding the principle of acceding to the Geneva Act, but also regarding the legislative proposal itself. The decision of the government was postponed due to the corona crisis, but then it occurred in June this year, and examination and approval by the parliament is ongoing. Considering the delay that is provided by the law for a facultative referendum, which should not be the case due to the general support that was demonstrated for this proposal, the agreement should, so the Geneva Act should enter into force for Switzerland in July next year. So I will, I will focus my presentation on the way in Switzerland we plan to implement the Geneva Act. So here you have the 5 points I will develop. So the competent authorities, what will be registered by Switzerland in the Lisbon system, how we will deal with the international registrations in Switzerland, the issues regarding prior rights and flexibilities, and finally enforcement. So first of all, the competent authority, this is something that is mandatory according to the Geneva Act. We have to designate a competent authority. So this is the IP office for Switzerland. We have the experience of dealing with conflicts between geographical indications of source, and other IP rights, in particular trademarks. I will perhaps, I will develop the issue of fees from another point of view, but let me first mention that there will be no fees for applicants. And the idea is that it's also in the interest of trademarks, right holders and applicants that we clarify the rights applying to geographical names. And we also have a close collaboration with the Ministry of Agriculture regarding the assessment of what will be submitted to the system. Regarding the international registration of Swiss GIs, here we had to elaborate a little bit more. So generally speaking, the Geneva Act is very detailed, provides so that its provisions are directly applicable, at least in the Swiss legal system, and we came to the conclusion that we did not have much to add to this basic international agreement. But one of the things we had to add was the definition of potentially applying GIs in the system. So just to know that in Switzerland we have our general legislation providing the protection of GIs without any registration. But we came to the conclusion that there should be a national title of protection as such, in order to submit the application to the Lisbon system. So this is a kind of restriction, just because we don't want to process a substantive examination of Swiss GIs before entering or before submitting these GIs to the Lisbon system. So these titles of protection are, let's say, the very classical ones. So sui generis title of protection for GIs. And we also provided the possibility for trademarks to be registered under the Lisbon system with very restrictive criteria. That is to really consist of a GI, which only concern a very limited number of exceptions so trademarks that were registered a long time ago or due to particular circumstances. So applicants, we also had to define that applicants will be the representatives, so let's say the organizations or authorities representing in each case the stakeholders. Just because, except for trademarks, the Swiss legislation does not recognize any owner of a GI. The issue of language was very easy to solve due to the fact that French is at the same time one of the working languages of the Lisbon system and the national language in Switzerland. So French language will be mandatory for all the procedures. And yeah, finally, the procedures will be based on the templates, so the forms that will be that are provided by the WIPO. As to the protection of international registrations, so that is to say foreign GIs in Switzerland. So some views very quickly. So first, the publication. We won't publish the international registrations. So we, generally speaking, there is a part we try to do parallel between the way we address the Madrid system, or we implement the Madrid system for trademarks, and the way we will implement the Lisbon system for GIs. So the registry is established by WIPO, and so this is the place where everything will be published. We won't add another publication channel. The examination will be based, like for trademarks, both on absolute grounds, so that will be examined ex officio. So the respect of the definitions set by the Geneva Act, and so on, and all relative grounds, so let's say conflicts with prior trademarks or prior uses, will be examined on request by stakeholders. As to fees, there will be only fees for oppositions or requests so requests in relation to prior uses. In our view, under the Geneva Act, there is no need for notifications of grant of protection. This is also in line with our legal concept that GIs are protected without registration, so also without registration. So we plan to not publish any notification of grant of protection. On the contrary, of course, we will publish refusals, and in particular partial refusals that we intend to use as a way to respect prior trademarks or prior uses or conflicts of homonymy and so on. So as to the prior rights, the flexibilities that are introduced in particular in the regulations of the Geneva Act, so we limited our, let's say, our picking of those flexibilities to a small number. So first, the coexistence with prior trademarks, which is proposed or provided as a possibility under the Geneva Act. In our implementing legislation, it will be the rule, so the principle, and non-coexistence will be the exception. So just in case a trademark would be that strong and that damaged by a subsequent, let's say, geographical indication. We also, that is necessary to provide in the implementing national legislation the possibility of grandfathering or phasing out. So this is what we did. The procedures, I talked about them. So I will just mention that we we do not intend, and it is not what is proposed, to use any additional requirement like so optional mandatory content of applications as provided under the regulations of the Geneva Act. Let me mention in particular the issues related to enforcement. So first, so enforcement of the way we intend to enforce the protection of international registrations under our domestic system. So first, as to trademarks registration is concerned, then there will be the same mechanism that is used already for GIs protected by bilateral agreements. That is to say, there will be a limitation of the list of goods to goods benefiting from the said GI. In that case, we will also so the means that are available for all registered GIs will be also available for GIs protected under the Geneva Act. That is to say, for foodstuffs, the cantonal, so let's say regional authorities in charge of monitoring the market and repressing the frauds. And for all GIs, the administrative measures that are available by customs. And finally, all civil and criminal procedures that are available for indications of source in Switzerland, including the reversal of the burden of proof, will of course be available for GIs protected under the Geneva Act, of course with the same, so according to the standard of protection that is provided by this act. So let me finish with some general views. So first of all, we proposed a legislative amendment of our law on the protection of trademarks and indications of source that is very light. It's only 4 new articles, one of them being kind of introductory one, and the last of these 4 articles being just a legal basis for fees that, as I said, won't be used for the registration itself, be it the registration of Swiss GIs or the examination of foreign GIs under the Lisbon system. So one of the very practical reasons being that there is no fees for the registration of appellations of origin or geographical indications under the system that is administered by the Ministry of Agriculture in Switzerland. And so for the national treatment, we could not impose such fees for foreign GIs. But the other, let's say the other, so the basic or the most important reason being the small number of let's say of GIs that will be submitted each year, and also the fact that under other systems or other tools like bilateral agreements, there are no fees. So we think it's a good thing that there would be no fees as well in this coherent and transparent system. Generally speaking, our aim was to mirror the provisions for the implementation of the Madrid system for trademarks. So as far as the procedures and so on are concerned, the whole system that would be available for Swiss stakeholders is based on demand-driven procedures. So I talked about the question of fees, and finally, our expectation is to have a regular and reasonable flow of international registrations, so that the system is our participation to the system keeps being manageable. And perhaps this is quite a concern for Switzerland, but it is also a very big concern, we guess, for the accession of developing countries. So on our side, we will try also not to overwhelm the capacities of the system and of its members. Thank you so much for your attention.
Thank you very much, Mr. Devenomaten. I have two questions so far to you. Question one. You said that in order to consider an application submitted under the Lisbon system, a bureau for intellectual property should be established in Switzerland. Correct me if I'm wrong, this bureau does not exist yet, and this has to be a special organization, not the institute you're representing right now.
No, sorry. Maybe there was something unclear in my presentation, but this is the Swiss IP office, so the Institute for Intellectual Property. That will be the competent authority for the administration of the Lisbon system for Switzerland.
So this is going to be an individual entity, not the entity which considers applications of trademark, for instance, or any other individualization, right?
No, sorry, the same. So the existing IP office will administer the Geneva Act. So the same IP office dealing with trademark registration.
All right, thank you very much. So question two, which I have also received. In the beginning of your presentation, you mentioned around 5 stages of joining the Lisbon system. Which stage, in your opinion, is the most difficult one to implement? Because we find it important in view of the coming work to join this agreement.
So thank you for that question. My intention was to highlight the different areas where the Geneva Act requires that the national legislation of a new member says something. So I really I think all these 5 areas have the same importance. This is just this is just requested by the Geneva Act and its regulations, that that something is addressed in the national legislation in this regard. There is the option of perhaps with the exception of the competent authority, of course, that must be identified. But we can imagine that nothing would be said about the 4th last point, but then it would probably cause some problems in specific cases. So I just wanted to communicate that in Switzerland we considered all those 5 areas, and we I think we answered as light as possible to the requirement of adding national legislation on these issues.
Thank you very much for your clarification. In our work, we'll look at your experience of joining the Lisbon system. I think that all these stages will also be quite typical of our future work as well. Thank you. And now, dear colleagues, I would like to give floor to a representative of Russia, a representative of our agency, Larisa Bardai, head of the Department of International Registration Systems. This department currently deals with applications for other means of individualization that we receive as part of other systems, the Madrid system and the Hague system. So it is quite possible that when Russia joins the Lisbon system, applications submitted under this system will also be ending up at her department. Ms. Bardai, you have the floor. Thank you, Andrey. Good afternoon, or maybe good evening, dear listeners, dear participants of this conference, of this session, dear viewers. It's a bit unusual to work in this format, but still. First of all, I would like to give a certain disclaimer. Initially, we intended to give floor to Svetlana Gorbina, main researcher of our agency, but she cannot participate in this conference. But I'm convinced that she's with us remotely, because she is the main researcher in Russia with respect to geographical indicators and appellations of origin. We have had this concept since 1992 in Russia as part of the law on protection of trademarks and other marks of use. And Svetlana always enjoys to tell about this. Now, I would like to begin my presentation by a lyrical and gastronomical introduction. 4 years ago or so, I found a magazine called L'Officiel Voyage. It's a French magazine. This was the Russian language publication, a special publication about traveling. There was a very interesting article there. It was called Follow the Taste. I would like to quote from it, and I would like to show some pictures from this article, and maybe some quotations. So the author says, you can open Russia in different ways, through its literature, through its architecture, through its fine arts. But sometimes it suffices just to sit at the table and to learn Russia by learning new tastes, which can be quite encouraging as well. And this article lists a number of products that are directly related to the Russian Federation as the area of origin. For instance, the Altai red deer, the Baikal omel, the Pskov snitok, or the Rostov crayfish, or the Suzdal cucumber, and the Yalta onion. Well, I all know that in France, for instance, the French have raised the crayfish to the cardinal level. Our Rostov crayfish also deserve special attention in this respect, and in the future they also may be registered as the appellation of origin or the geographical indication, depending on the conditions of this procedure. Excuse me? Now, you can see the pictures here. It should be noted here that the Rostov crayfish is a general name, because there's a number of these species. The Don crayfish, Salsk crayfish, it's a special local population of crayfish which has been going down in the past years, but still everybody knows this product in Russia very well. And we do wish this product to be registered at the national level to start with. And then later on, as part of the national system of registrations, should also be registered in all the countries which are members of the Lisbon system. I would like to skip these pictures right now. Those of you who are interested can have a special closer look at this publication. And now let me focus on the Suzdal cucumber. We have the appellation of origin Lukovici cucumbers, but there's also a Suzdal cucumber. And every year they celebrate the birthday of this cucumber in the city of Suzdal in the Russian Federation. This product and this appellation can be registered in the future as the geographical indication. Or let's take the Altai red deer. It is already registered as the appellation of origin of the product. The red deer from the mounts of Altai in 2006. So there are lots of products in Russian Federation related to geographical environments and their area of origin. And in my opinion, they deserve attention, both from the producers of these products, but also from their consumers. Well, broadly speaking, geographical applications of origin imply traveling. When you travel, you discover one country or another. You can select adventures, emotions, and new discoveries. This is an extremely interesting topic. But now let us proceed to discuss the outlooks for the Russian Federation in joining the Geneva Act of the Lisbon Agreement. From the presentation of our colleague from Switzerland, we have seen that they have made quite progress in this respect. They have a clear understanding of how to act. They have outlined all the steps and areas of their work. We can even see concrete dates when they're going to join the Geneva Act in the coming future. I would like to tell you what we have done in the Russian Federation so far. Well, firstly, we raised this question before the scientific community. We started a research. It was carried out at the Federal Institute of Industrial Property. And we researched whether it was possible and expedient for the Russian Federation to join the Geneva Act. And as part of this research, Svetlana Goring was the manager of this research project. We analyzed the Lisbon Agreement. We analyzed the Geneva Act as the new version of the Lisbon Agreement. Both separately and jointly, we did the comparative analysis. And as a result of this analysis, we came to a conclusion that the Geneva Act has a number of benefits, which Director of the Lisbon Register, Alexander Garcioli, has already outlined today. This is why the Geneva Act is, at the moment, is the act which we are, at the moment, ready to join. It should be noted that one of the clear benefits for the Russian Federation is that, one, a new concept of geographical indication has been introduced. Two, the issue of... What's this? Sorry. New provisions on individual fees and administrative excise was introduced. The Russian Federation, as an observer, has participated in this work. A lot of work has been carried out on the part of the working group for the development of the Lisbon Agreement, both at the diplomatic level. This proposal was also submitted by the Russian delegation, the proposal to introduce individual fees. As you all know, our country and our agency has been involved in expert assessment of these applications. We also charge fees for continuation of appellations of origin and geographical indications. This is why it clearly became a starting point in our decision to join the Geneva Act of the Lisbon Agreement in the future. Based on this work, back in 2016, 2017, there was no such thing as the geographical indication in this civil code. This was probably the only barrier for Russia to join the Geneva Act. And furthermore, the Geneva Act did not come into force either. Everybody was waiting for the first 5 members of the Geneva Act of the Lisbon Agreement. At the moment, as it has been mentioned today, the law has been passed already, or rather, amendments to Part 4 of the Russian Federation Civil Code have been introduced, And now geographical indications are an individual object in the Russian law. So we now have two items of individualization related to geographical indications. And starting from February the 26th, 2020, the Geneva Act of the Lisbon Agreement came into force, and it became another starting point for us to accelerate the process of getting prepared for preparing a plan of actions aimed to accept international applications with respect to the future journey of the Geneva Act of the Lisbon Agreement. This action plan includes a number of chapters, and they are as follows. One, active interaction with between the Rospatent and the respective authorities of the Russian Federation. At the moment, these documents have been submitted to the Ministry of Economic Development. They're undergoing the process of approvals. Furthermore, clearly we need to be in close contact with the administrator of the Lisbon system, the WIPO. Alexandria will confirm that at the end of 2019, a number of events were held with the International Bureau of WIPO. Meetings and workshops were held to prepare this preliminary set of documents. We discussed various nuances and provisions of this future journey of the Geneva Act. I hope this was not the last meeting, and we will hold more meetings to accelerate the process of our accession to the Geneva Act. Next, our action plan includes a number of technical and technology steps and procedural issues related to international applications in accordance with the existing laws and norms that we have in the national legislation. In my opinion, this is one of the most important steps that will take a lot of effort, require a lot of resources in terms of outlays as well, because we will have to carry out a comprehensive approach to solve all the above-mentioned tasks and to bring them into compliance with international legislation. Another step, which is just as important, is to publish information materials and notifications to Russian users, because it may happen that not all users, not all applicants have an idea of what geographical indication or appellation of origin is. Clearly, there are some more advanced users, more advanced producers, who over the past decades have had the appellations of origins registered. But they so far have been facing problems when they enter international markets. They face problems to get protection in other countries. As you all know, in the previous section, our colleagues from the Rospatent mentioned that a lot of meetings have been held to discuss the process of introducing the new process of a geographical indication in Russia. But we also intend to hold meetings like that, maybe workshops and webinars, to discuss the future submission of international applications under the Lisbon system. Beside the question of how this works, we also need to raise awareness in Russia. We need to educate our industries on the importance of appellations of origin and geographical indications, both in terms of economic, but also in terms of cultural aspects, because we all realize that these objects are unique. They cannot be many as opposed to trademark applications or inventions. So they do take a special niche, while at the same time they take a lot of efforts to promote them, to keep them up to date, and to promote them both at the national and international levels. So we hope that the fact that we're going to join the Geneva Act of Lisbon Agreement in the future will help us, among other things, to solve these tasks too. And another important point is the chapter of our action plan to solve administrative, financial, and personnel problems. What do I mean by administrative and financial aspects? This is related to providing support for work in this respect. Furthermore, it's about further registration fees, both on Russian users and on international users, both individual fees and administrative fees. Furthermore, we need experts, we need personnel to solve these tasks. So this is why we believe that this action plan will be implemented in the very near future. And our future accession to the Geneva Act will open up the ways to Russian users to this international effective mechanism of legal protection. We will be able to protect both Russian appellations of origin and geographical indications abroad, but also foreign GIs and AOs in Russia. We know that international applicants, before the GI concept was introduced in the Russian law, face problems registering their indications. This is why the new Russian law and our future accession to this act will serve to solve this problem. Well, I can tell you very briefly that these items have an economic value, are economically attractive in terms of investments. This will increase turnover between the countries. This will increase the competitive value of these products. If we register geographical indications and appellations of origin in Russia and abroad, this will be very useful. And clearly everybody expects to derive profits and revenues, both the industries that provide these products, but also the respective budgets of the countries. And we'd like to wrap up my presentation on a lyrical note. We expected to see here people from the Association of Folk Arts and Crafts. So I would like to use a product offered by a member of this association, the factory of Koklama handicraft. You can look at this item offered by the Museum of Decorative Arts. They launched a project for rethinking the approach to Russian traditional folk crafts from a modern point of view. We all know that these are traditional products, folk products. They're historically related to Russia. They have some archaic symbols embedded in them. But for this to develop in the future, for this to join the process of development, we need to look for new ways to modernize them. I'm going to read this out. The authors of this project describe the idea behind their project, so that our speakers and our guests from WIPO and the EU and Switzerland will understand what I'm referring to. I will use a very simple product, wooden plates. These wooden plates became a part of a big project to rethink Russian traditional folk crafts. This unusual collection helps us to work with collective memories. We research how you can use old meanings and fill the idea of distant past. Traditional colors of Koklama painting, black, red, and yellow, are presented in an unusual way, which is not an icon of the past. No, it becomes a symbol of the new generation, a generation which remembers its roots but has its own character. I'm not going to read out the text of this second picture, but I hope you get the idea. So I would like to express my deepest thanks to everybody involved in this process of reviving and restoring folk arts and crafts in the Russian Federation. I would like to thank you for your attention. If you have any questions, I'll be happy to answer them. On this slide, you see the signs and emblems of protection of appellations of origin and geographical indications prepared by Rospatent as part of the process of introduction of geographical indications in Russia. Thank you. Thank you very much, Larissa. If our foreign colleagues have any questions to the speaker, they're invited to ask these questions using the audio connection. If anybody in Russia has questions to our speaker, those who are watching us on YouTube right now, you're invited to ask these questions in writing. I have one question to Larissa now, but I think you have already answered it in your presentation. The Russian legislation on geographical education has existed for a long time. Why did Rospatent decide to join the Lisbon system right now? And maybe the answer is because it's high time that we did so. But actually, after the new Geneva Act of the Lisbon Agreement came into force, which was initially adopted at the diplomatic conference in 2015, and the benefits which we have heard of this act, clearly it will be a good step for Russia to join this act. Furthermore, it will help us to cover, like I said, two items, not just appellation of origin, but also the geographical indication. This will open up doors that will give a green light to foreign users to register their geographical indications. Because as we all know, an item of geographical indication does not exist in all the countries. It is rather typical of the old world countries, of Europe. So we have decided to go along this classical path. But China or the US, for instance, they don't register AOs, but they rather register GIs. So I think this is the most right thing to do, to start joining the Geneva Act in view of all the benefits that it offers. Thank you, Larissa, for your extensive answer. In your presentation, you mentioned that Russia is rich in various folk arts and crafts. Russia is also rich in various beverages, alcoholic and non-alcoholic. So now we have here Natalia Ostapenko. She's head of the Committee of Bottled Water from the Committee of Mineral Waters and Non-Alcoholic Beverages. They're one of the active users of the system of protection of appellations of origin and geographical indications. So Natalia is going to tell us about the development of the union and whether they're interested in Russia's joining the Lisbon Agreement. Natalia, you have the floor. Yes, thank you. I'm representing a business here that uses appellations of origin and geographical indications concepts. Our union unites many producers of mineral waters. At the moment, the biggest number of registered appellations of origin comes from the producers of mineral waters. Our members of our union includes a company holding Aqua, which bottles such famous mineral waters as Yesentiki 4, Yesentiki 17. The speaker has not been able to come over to us from the Caucasus, so I'm going to read out his report. Limited liability company holding Aqua is a public-private partnership, a subsidiary of the Caucasian Mineral Waters company, the largest user of mineral waters from the North Caucasus. It was established in 2017 in order to create a vertically integrated producer of full cycle. At the moment, Holding Aqua bottles waters, Yesentiki 14, Yesentiki 7, and other mineral waters. All these waters have geographical indications. World-known mineral waters, Yesniki 4, Yesniki 17, are registered as appellations of origin, registration number 23. Only this company is entitled to bottle Yesniki 17. This is the order which was introduced owing to the law which is currently enforced in the Russian Federation. And after this law was updated, because until the year 2019, 80 appellations of origin of Yesniki 4 and 17 were registered. No. 20 Yesniki mineral waters were registered in Russia until this law came into force. And these AOs were used to bottle water from totally different regions, which had nothing to do with the Yesniki. So, this tool was used to enforce individual provisions of the law and to enforce issuance of protection documents, to update the standards on mineral waters. And this helped to reach a situation finally where Yesniki, Narzan, and Slavenovska mineral waters began to own these trademarks and these appellations of origin. And now the company that bottles in the water from these particular sources has a right to use these appellations of origin. In addition to bottling water for the internal market, we would also like to enter the international market. This is why accession to the Geneva Act on the necessity of system of registering AOs in Russia and abroad is as relevant as ever. In accordance with the Geneva Act, names protected in Russia can be protected under the Lisbon system by just one application. As a result, this Lisbon system, after just one application is submitted and one set of fees is paid, will ensure effective protection of the name of product that have a good quality. Russia's joining of the Geneva Act of the Lisbon Agreement will simplify significantly the procedure of getting the necessary protection for Russian products worldwide. I think this applies not only to mineral waters, but also to any other products. As I was listening to your report, I wanted to ask one question. With your permission, if the Russian Federation signs this agreement, then our trademarks will be protected in the countries which are signatory to this agreement. Is that right? Yes, Larissa, please.
На данный момент ваше наименование мест происхождения?
Да, вот наше наименование мест происхождения.
So probably you mean our GI, which is being registered in Russia. I understand that not all the countries have signed that, the Lisbon Agreement, and just the number of the countries' signatories is limited, and our trademarks will be protected only in the countries signatories to the Lisbon Agreement or signatories to the Geneva Act, to the Lisbon Agreement. There are only 5 countries like that there at the moment. But we all hope that this would be the Geneva Act which will extend the scope of the Lisbon system, and we as the hopefuls expect to accede to that and increase the number of signatories. Well, if the countries which were listed really subscribed to Geneva Act and Lisbon Agreement, this is already quite interesting for us. There are some problems which may arise in that field, and actually protection of GI is very costly, it is very time-consuming, it requires a lot of human investments if you have to go to individual countries in order to register and protect a trademark. But once the application is unified, our brand names as Novokarachinskaya, Novoterskaya, and other potable water could actually be protected by GI. Thank you so much, Natalia, for your explanation and for your presentation. I think that the potential users of the Lisbon Agreement, this is the main reason for Rospatent, and the Handicraft Association will also be very much interested in that. I communicated to the head of the Handicraft Association, and he assured me that it would be not only the Association of Non-Alcoholic Drinks which will support our accession to Geneva Act. When the latest amendments were made to the Russian Civic Act, our union, along with the Handicraft Association and the Winemakers and Tea Makers Association, participated in the drafting of the amendments, and the law looks now very nice. And once the protection embraces all the signatories to the Geneva Act, that would be very interesting for us as well. Anyone who registers trademarks usually would be the producers who are interested in the extension and development of the business, who invest their own money into the development of the business. And when the trademark acquires a reputation, there is a temptation to misuse this trademark. And therefore the protection of trademarks is clearly very important. Thank you so much for your explanation. I have one more question to Ms. Borodai. In your presentation, you actually showed some emblems. Who can use that? Are there any regulations on that? Thank you so much, Mr. Zhuravlev. These emblems were designed by the Federal Intellectual Property Service and Rospatent, and they are enforced by a decree by Rospatent, and the Ministry of Justice also issued certain decree on that. So they showcase these emblems in black and white and in color, but regarding any special regulation on the use of these emblems, as far as I know, there are no such acts. But I assume that these emblems can be used by all the holders of the GI, of the appellation of origin, or those who have the right to use that. So they are entitled to use this emblem along with the registered appellation of origin or GI. And I think that this is enshrined in our civil code, in the section related to the rights holders. And probably an individual regulation would be needed to use such emblems. Probably our colleagues in Rospatent can elaborate on that. So at the moment it is not clear. Do we have the right to use that sign or trademark, or we have to obtain special permission? I assume that if you hold the GI or hold an AO, then you may use this emblem without any extra permits, just because you are the legitimate holder of the GI or of the AO. If you are not such a right holder, or if you do not hold the right to use this trademark, then you cannot use this emblem. I assume that it actually is applicable only to the registered emblem and trademark. Such practice, and we can ask our colleagues from the European Commission, and probably we can replicate the experience of our colleagues when creating such emblems. That's a very popular thing. Then I have another question. If you put that trademark onto the label or marking, are there any requirements as to the size? For instance, if you got registered for instance, the Eurasian Commission, then you may put this sign of the Eurasian Commission on the label, but it has some requirements as to the size and color. Are there any requirements regarding these emblems? Actually, these emblems were drafted and designed by Rospatent, and I think that once they were enacted by the Rospatent, the way actually they were shown on our slide with the decree, there is a supplement to the decree with visualization of these emblems. This is the way they have to be portrayed, have to be used, but I think that our colleagues from Rospatent have to specify that and clear it out. Yes, we'll get in touch with you. Thank you. I have one more question to all our foreign speakers. Almost all of you mentioned that bilateral agreements would include the so-called an evocation. Can you tell more about that evocation clause regarding the GI? Can you draw some examples?
Dear colleagues from WIPO, from the EU, from Switzerland, can anybody of you answer this question?
It's John Clark from the European Commission. I'd be happy to say a few words. So there's an echo. Maybe you can switch off the mics. Thanks very much. So arguably, evocation is already covered in the TRIPS agreement and in international laws on GIs, because GI protection prohibits any use, any act that can suggest that a product comes from the another place, the real origin. But this has had to be made more precise in our international agreements. One or two examples. A lot of Australian and American and New Zealand cheese producers produce a cheese made from cow's milk, which they call feta. Feta is a very, very iconic and famous Greek cheese made from sheep's milk or a mixture of sheep's and goat's milk. And they don't call it feta when they put it on the market in China or Japan, but they put it in a package where they use they have a picture of Greece or a Greek island, or a picture of a sheep, or a picture of the Greek flag, or Greek lettering. So they're not actually pretending or saying this is feta cheese, but they're suggesting, they're giving evocation of feta in the packaging and labeling. This is very common. Another example, Scotch whiskey, although that won't bother the EU after January next year. A lot of producers of whiskey, they don't call it Scotch, but they have a Scottish name for it, like Highland Glen or Trossachs or the Highland kilt or bagpipes. They have a picture of a Scottish man in bagpipes with a kilt, like my grandfather used to wear, and it's an evocation of Scotland, so that the consumer who is not very sophisticated will think that's the real thing, that's the real Scotch whiskey, with all of the tradition and the know-how and the reputation and the care, and will buy it. So evocation is all about what happens on the label of the product to make it resemble a GI without using the name.
Mr. Clark, thank you very much. I think the answer is quite clear, at least clear to me. But I think the person who asked this question also understands what's going on. Do other speakers have any questions, or do our listeners from the outside have any questions? Questions to speakers Or do speakers have any questions to each other? If you don't have any questions, then with your permission, I would like to sum up a result very briefly. You know, I think we have done a very good job. We have worked very fruitfully. I received a lot of new information about the Lisbon system, about the Geneva Act and its system, and the geographical indications and appellations of origins as such. We at Ross Patent will have to go a serious long way before we join the Lisbon system. And I think that today's meeting is a very useful one to our experts. We will watch all the videos many times, we will watch your presentations, and clearly we will meet with the speakers from the WIPO, with the speakers from the EU and Switzerland, and we'll be in close contact. And we'll work together to reach our common goal to improve the legal protection of such important items as the appellation of origin and geographical indications at the national and international levels. I would like to thank everybody for their presentations. I would like to thank everybody for their attention. I call our session closed.
Thank you.